Hello. Just going to, yeah. I believe that now people can see me. Wonderful. I'm seeing nodding heads and thumbs up. That's a good sign normally. Good morning, good evening, good afternoon, everyone, depending on where you are. I'm trying to accommodate time zones for everybody. Welcome you to today's webinar, which is going to start here in just a couple of seconds. We're going to speak about a very, very interesting, a very contemporary topic, which is called institutional mediation in the Middle East. I'm very, very thankful to be here on an invitation from the Tehran Regional Arbitration Center. Very honored to be your moderator today. Now, mediation is a method of conflict resolution, and when I think of conflicts and the Middle East, what comes to my mind first is the Holy Quran, which in many, many instances says that amicable settlement, which is something that you can reach in a mediation, is the best way of solving disputes. And I believe that in that spirit, we will hear many excellent presentations today. Allow me to introduce our speakers today to you. Starting with Our Lady, Amanda Lee. Amanda, I do not think I have to introduce her to anyone, and I'm going to say that with every one of our speakers. Amanda is an international arbitrator. She is the founder of Careers in Arbitration, a wonderful platform that everybody who doesn't know it yet should definitely check out. I am on there. And she is a visiting lecturer at the University of Law in the United Kingdom. She's also a very nice person, if I may say that. That also goes for all of our speakers. Now, turning to the gentlemen, we have Dr. Owais Rizvanian. I hope I say your last name correctly. He is the director of the Tehran Regional Arbitration Center. So we're here basically on your invitation today, I would say. And he is also an international arbitrator and a mediation specialist. We have James Claxton, who is an associate professor of law at Waseda University in Japan, and who is also an independent mediator, and who really knows about mediation, as I could recently see on one of his Kluwer arbitration blogs. And we have, or Kluwer Mediation, I'm not sure which one of the two platforms it was, I'm reading both. And we have Dr. Kabir Dugal, who is a senior international arbitration advisor at Arnold & Porter, and who also acts as an independent mediator, and who is also involved in REAL, an initiative to create or foster more diversity in international arbitration. Now, my name is Michael Wieczorek. I'm an attorney at Taylor Westing's Munich office, and I'm also a director of Africa in the Mood, which is an initiative trying to bring more teams from the African continent to the Willem Siewes International Commercial Arbitration Court. Now, coming to our topic today, mediation, institutional mediation in the Middle East. I think since we are here in Iran, on the legal framework for mediation in Iran, and generally, how is mediation perceived in Iran?
Yes. Do you hear me, Michael?
I do.
Thank you very much, Michael. Thank you. So good afternoon, everybody. Good morning, good evening, whatever. Mediation in Iran has quite a history behind it. Let me say like that, in the few decades ago, due to increasing number of cases filed in the court, the Iranian legislator decided to take an initiative step and introduce a new body called as Shorai Hal Ikhtilaf. We call it as Dispute Resolution Council, and let me call it DRC from now on. And the main task of this DRC was to deal with small size claims. That means that when the claim amount was less than a certain threshold, the dispute was forced to be referred to that mechanism, to that body. And well, there was less formality over there, and plus there was not only the lawyers, there were not only the lawyers over there, but the engineers, the accountants, the quantum experts, whatever, could decide about the different cases depending on the nature of the case. So that was quite a big step by the legislator, but it was not mediation, because first of all, there was not a voluntary basis because the parties were forced to be referred to that mechanism. And second of all, there was a binding decision at the end of the proceeding, which was like a court judgment enforceable. So why am I talking about that? Because in addition to this main task, there was also a side task assigned to this body, and that was to attempt for resolution of the disputes, commercial and civil disputes between the parties. And although that was a side function, that proved to work very efficiently. The best example that I can give of these type of disputes is the disputes arising out of car accidents, and not about the personal injury, but about the quantum of the loss that each party might have incurred in a car accident, either for repair or fixing the car, or for decrease of the price of the car after fixing it. Therefore, when the parties go to this council, the RC, there are some people over there, and they attempt to make the parties' position closer to each other. They listen to the parties and they talk with them, and somehow they warn the parties that if you go to the court, what a lengthy process will be waiting for you there. And that helps the parties to come to a solution. And if we look at the percentage of the disputes who come to a solution at this stage, this is really amazing and working very efficiently and very good. And I mean, and that is the indeed the people over there, indeed the people in those panels are doing mediation, although they have not educated in mediation, but by experience they know how to make the parties' position clear, closer to each other. So that's why I am saying that mediation in Iran, at least in the last few decades, had a history, at least in the judicial level. But when it comes to the private level and in the institutional level, the situation is somehow different. I mean, we don't have that much records in this regard. And I will talk about this matter later in my next parts of the talks, if Michael allows me later. Thank you.
Of course, I will allow you that. That was already quite insightful. So there is not much of an institutional tradition, if I gather that, in the mediation and the dispute resolution institutions as such. And that brings me already to my first question to James. James, would you agree with me that there is a growing use of institutional mediation in the world? And could you maybe share with us some of your thoughts on the future of that mediation practice within institutions?
I'd be very happy to. First of all, thank you to TRAC. I'm keeping excellent company today with my illustrious co-panelists. Really, thank you very much for including me. A question behind your question might be why mediation needs the support of institutions. After all, mediation tends to be short and procedurally simple when compared with arbitration, and participation is normally voluntary. Parties can end the process at any time. That said, I think that the role of institutions is as important for mediation as for arbitration, and maybe even more important, though for different reasons. Let me explain by identifying 3 things that institutions can do to support mediation. First, they can be a source of information. Businesses tend to be less familiar with mediation than arbitration. Mediation is meanwhile practiced differently around the world. In these circumstances, institutions can inform businesses about the mediation process, good practices, when to mediate, and about the comparative advantages of mediation. The role of regional institutions may be especially important. They can provide information in the local language and may have the attention and trust of local businesses. Second, dispute resolution centers can help parties to choose mediators. The community of international commercial mediators is not well known to most businesses. Meanwhile, there is a diversity in mediator specialization and practice. Some mediators are good at managing direct party conversations, while others are better at offering critical feedback in private meetings. An institution with good and current information about mediators can help parties to find the right mediator to fit their case and their expectations. Third, institutions can play a formative role in shaping mediation policy. The modern mediation infrastructure remains new at the international level. The Singapore Convention on Mediation and the revised UNCITRAL model law on mediation were concluded just last year. In most states, there are open questions to be resolved. What changes to domestic law are needed to support international mediation? Should the Singapore Convention be ratified? And should states that adopt it make reservations? Is there a workable code of conduct in place for international mediators? Institutions like TRAC are well positioned to assist the legal community, the business community, and the government to navigate such important issues and to ensure the viability of the process.
Wow, those are quite a lot of open questions that would need answering. And then on top of all of that, we are currently still in this global pandemic. I believe everybody of you has heard about it. It's called the COVID-19 pandemic, in case you haven't. And that poses even more questions for mediation. It poses many questions for arbitration that I know about. But I would like to hear about which questions, which chances, maybe which advantages the pandemic has brought to the mediation landscape. And Amanda, I believe you're the one who could answer me that question.
Thank you very much, Michael. Well, first of all, it's my pleasure to have the opportunity to speak to you all today. I'm very grateful to the Tehran Regional Arbitration Center for the kind invitation. I'm going to focus on advantages. Let's be positive. From an access to justice perspective, perhaps the greatest challenge posed by the pandemic was how to continue to facilitate the resolution of disputes during a period when it was vital to maintain social distancing to protect public health. Although online or remote mediation is not new, thanks to advances in the affordability and accessibility of good quality video conferencing technology, mediation was particularly well positioned to thrive during the pandemic, to the extent, of course, that any of us could really thrive during the pandemic. The advantages of remote mediation range from the practical to the psychological. On the practical front, with no need to rent rooms in which to mediate or incur the costs of travel, parties make immediate savings on the logistical costs of mediation. And this makes mediation more affordable and consequently more accessible, particularly to those whose financial position may have been impaired by the effects of the pandemic. The pandemic unleashed an onslaught of claims. As we will all recall from the many webinars on the topic, force majeure and hardship were recurring themes. Thankfully, once the parties agree to mediate and choose a mediator, mediation proceedings can be swiftly convened, particularly with the assistance of an institution. After all, in times of crisis, parties want the comfort of swift recourse to dispute resolution, and even an unsuccessful mediation offers an opportunity to narrow the issues between the parties, take stock of the merits, and reflect on the costs of litigating if the proceedings are ultimately unsuccessful. Remote mediation is more conducive to cross-border dispute resolution than in-person mediation too, enabling parties from different parts of the Middle East and beyond to meet at their convenience, and ensuring that travel and the need to find a neutral location are no longer barriers to attempting mediation. Although many have struggled during the pandemic, there may be sound commercial reasons why keeping difficulties confidential is important, and mediation continues to offer this advantage over court proceedings too. Mediating remotely saves time, there's no need to travel to an agreed location, and the participants have ample time to recharge in their own environments between sessions. As a result, the parties are better placed to maintain their stamina. It makes it easier to avoid losing the motivation to settle during a lengthy mediation day. I'm sure we've all experienced one of those days where the mediation doesn't settle till 2 o'clock in the morning. It makes the time that you're investing more likely to be fruitful. And from a psychological perspective, the comfort of mediating in a familiar environment instead of a meeting room with, in some cases, I'm sure not at the Tehran Regional Arbitration Center, of course, but in some cases, bad coffee and poor lighting are often what you find in mediation facilities. These factors can result in reduced stress and anxiety for the participants. Elderly users, those with complicated medical needs, and those who have difficulty traveling are particularly well placed to benefit from the move to remote mediation. The mediator must also be constantly cognizant of threats to the settlement equilibrium, and remote mediation offers advantages in this regard too. For a properly trained and technically savvy mediator, making sure everybody is visible on screen is far easier than worrying about setting up the room for the joint session in a non-adversarial manner, or how to ensure that the parties avoid awkward encounters in the lobby or the elevator. And that's particularly important if you're dealing with a family dispute or a trust-related mediation where an unexpected encounter may be particularly traumatic for those involved. And last but not least, before Michael throws something at me for going over my time, during a period of crisis, it's particularly important to feel in control. Mediation is voluntary, and it gives parties back some of that much-needed control. Although we often say the mediation process belongs to the mediator, the mediation itself belongs to the parties. The destiny of their dispute is firmly in their hands, the mediator tasked with facilitating and exploring potential solutions, not imposing resolution upon them. Unlike court proceedings, where the parties are at the mercy of court timetables, mediation is flexible, and that is perhaps its greatest advantage in times of pandemic and beyond.
Right. Wow. That sounds like a very, very promising answer. It sounds like after 14 months of me wondering why we are in that pandemic, something good has come out of it. I'm very glad for all these insights from you, Amanda. I would still like to take one step back again, and I would like to take Owais up on his offer to talk more about history of mediation in Iran. It's really a topic that I'm very interested in and that I would like to learn more about.
Thank you very much, Michael. Thank you again. Well, as the director of Tehran Regional Arbitration Center, if I may, I would like to say a few words about TRAC mediation, because this is also a vision of the institutional mediation under the Iran legal regime. TRAC has had a long vision with respect to the need for an institutional mediation. After introducing the current version of TRAC arbitration rules, that is 2018, drafting mediation rules was aimed at the next project. As mentioned earlier, and despite the long history of mediation in judicial level of Iran, the legal framework of international mediation and domestic mediation has not been clear in private level or institutional level. Upon signing the Singapore Convention on Mediation by the Iranian government in August 2019, the need for regulating an institutional mediation was felt more than before. So TRAC, as a pioneer arbitration center in Iran and in the region, I would claim, started this initiative, took this step, and a team which had been led by my colleague, Dr. Mohammad Hussein Tawana, has worked on the project of drafting the mediation rules for TRAC. After several meetings and long discussions in different working groups within TRAC, well, I'm delighted to announce that the final draft of the TRAC mediation rules will be published for public consultation very soon, before end of the May. Well, this is not the first mediation rules in institution in Iran. We had the Arbitration Center of Iran Chamber, which also released the mediation rules before, but the mediation rules of TRAC is pretty much pretty much innovative and very newly drafted and very compatible with the recent trends of mediation in the world. I'm also happy to tell you that soon in June, TRAC will host another event which will address the mediation rules in very details. And I expect that the TRAC mediation rules will come into force by 1st July 2021. So I take this opportunity and invite all participants to participate in the public consultation of TRAC mediation rules, and we should very welcome any comments or any advice or suggestions the participants might have on that.
That sounds like an invitation that I would echo and that people should follow. So I assume that we would find the consultation or the consultation draft on the homepage of TRAC. Wonderful. So
Yeah,
I will tell everybody who is interested in mediation to have a look at that. Now, coming to a more delicate topic about mediation in Iran, do you see any current problems with that? Do you see any issues that would make it more difficult to mediate commercial disputes in your country?
Yes, thank you very much. That is a very good question, Michael. Well, to my best of experience, I see three problems, or at least problems in three different levels. The first level is what I call cultural problem, which means that the business user, the businessman, the parties in Iran are not assured that an amicable solution like mediation without any enforceable binding outcome would secure their rights to the best. That means that the parties prefer that instead of wasting their time, that's what they describe, the mediation. Instead of wasting their time, they just go directly to arbitration or litigation in order to receive what they wish to receive. So the first problem is the business users should understand the advantages of mediation. We went through this road for arbitration also in Iran. The same procedure for arbitration was passed. So I believe that we should promote the mediation among the business users in order to introduce them that how mediation, although might have not a very enforceable outcome, might help them to reach an amicable and very cost-effective solution. So that is the first problem. The second problem, I would say, is the problem in the level of the counsels, lawyers, in-houses, because most of the lawyers in Iran who are practicing either in domestic level or even in international level are trained for courts. They have recently somehow adjusted themselves with arbitration, but they are not prepared for something like mediation. They don't know what it is. And when they don't know, they have no incentive to encourage their clients to mediation. So how should the clients come to mediation? Somebody should give advice to them. And the lawyers, the counsels are not ready. So the second task that we should do in Iran is to educate, to help the counsels to learn more about mediation. And the last problem, I would say, is the lack of the legal provisions and legal infrastructure for mediation in Iran. We don't have I mean, any written piece of right, any written infrastructure for mediation, and therefore, when one party wants to refer to mediation or even explain it to its client, there is no legal provision for that. So, what I would say, these three problems are the most important ones in Iran.
Yeah, they sound like problems that need to be tackled, and they sound familiar to me from other jurisdictions as well. And they have been tackled in some jurisdictions already. But my question to you once again would be, if you were to dream of a future of mediation in Iran, what would that future look like, and what would it look like for the TRAC?
I would dream it very bright if you don't call me over optimistic. No, serious. I know, you know why? Kabir is laughing, but I'm saying why. Because in the last 10 years, I have very closely monitored the evolution of arbitration in Iran and the path or the roads that the arbitration went through. And I read a lot about before that. So I know that, I mean, like 10 years ago, the arbitration was not this common in Iran. Even the courts was not looking very well to arbitration. They were not friendly with arbitration. The parties were also somehow looking in a different way with arbitration without trust. And during the last 10 years, you can vividly see that how arbitration evolved into a mechanism that is working very well in Iran, and how at least two arbitration institutions in Iran have increased their caseloads, and how the courts are becoming more and more educated about arbitration. And now we have special branches for enforcement or setting aside of arbitration awards, which we did not have a few years ago. Now the judges are becoming very learned about that, and the lawyers are becoming very interested. The law students are eagerly pursuing the arbitration news in Iran that was not going on like 5 or 10 years ago. And I believe that the same path or same road will happen with mediation. We are in the beginning, I understand that, but the institutions like TRAC are starting to promote mediation in Iran and in the region. And I see that the law students are becoming more and more interested. They are taking their dissertations in the field of mediation. Or I see that many lawyers or many colleagues, counsels are asking about mediation. What is it all about? And plus, I believe that joining Iran to the Singapore Convention on Mediation is also quite a big step, which means that, or which shows that the state, the legislator is also interested to open the ways to mediation. So that's why I would say I see the future quite bright, although it might go slowly. I understand that.
That to me sounds like a very, very beautiful dream, and I very much look forward to seeing it become real in Iran in the near future. You said slowly, but my hopes are that it will become real very soon. Now, one of the things that you mentioned was education. And if we talk about education, what comes to my mind is a professor, and that's why I would like to give the floor to James to speak a little bit about online mediation. Tell us what it is, tell us how it works, tell us how we can use it for everybody's benefit.
Great. Thank you very much. I'd like to actually build a little on some very important insights that Amanda shared with us earlier. Of course, as she mentioned a year ago, as we all know, the COVID pandemic forced us all to accept a new life online, including mediators who were forced to move their practices online. And since that time, there has been really a seismic shift in attitudes. Some mediators who had never mediated online before the pandemic have now become vocal supporters. Most say they will continue to mediate remotely, even when physical mediation is possible. Some say they will mediate online by default. I recently concluded a survey exploring what mediators like and don't like about online mediation. I prepared a questionnaire, had it translated into 8 languages, and shared it with mediators around the world. About 500 mediators is as successful as mediation in person based on the survey results. About 71% of respondents say they have settled the same percentage of disputes online as in person. 10% report they have settled more cases online. While I don't think that online mediation will do away with physical mediation, it is clearly here to stay. I think this can offer an opportunity for forward-looking progressive institutions like TRAC. Online, institutions can administer mediation anywhere in the world. Geography is no longer the barrier that it once was. The online space can also facilitate collaboration. The Japan International Mediation Center and the Singapore International Mediation Center, for example, concluded a pandemic protocol last year. Under its terms, disputes are managed by both centers working together. Mediations are conducted online with 2 co-mediators. This month, the protocol was used to successfully settle a complex, high-value commercial case. The poet Rumi wrote that the garden of the world has no limits except in your mind. A lesson of the pandemic may be that our minds have been a barrier to progress. I think that the gardens of tomorrow now lie ready and waiting for those who are open to the digital world.
Broadening our minds and breaking down barriers to cooperate together. Another beautiful dream that is becoming reality as we speak. I'm really, really happy about everything that you have said. That sounds like the promising future, the promising dream that we heard about earlier might be there already for some of us, and in some aspects we're all working on it. Now, let me turn to a very different topic from the one that we just talked about. I mean, we're in the Middle East, and in the Middle East, one of the elephants in the room is oil and gas. Those are 2 of the things that the Middle East has and many other countries want. Now, this may lead to disputes, and my question for you, James, is how suitable do you see mediation to solve disputes in the oil and gas industry, especially in the Middle East?
Thank you very much for that question. In February of this year, as I'm sure all of you will know, a Swiss court upheld a more than 1.5 billion euro award against the National Iranian Gas Company in a dispute with a Turkmen state entity. The case had been ongoing for 4 years in arbitration and litigation. Oil and gas disputes are often like this. The disputes can be complex. They can take a long time to resolve in arbitration, and they can involve large quanta of damages. Mediation may offer better solutions than arbitration in these circumstances. Mediation is exponentially faster and cheaper than complex arbitration. It can preserve relations where parties need to continue working together, which may be the case for production sharing agreements, for example. Mediation can bring multiple shareholders together in the same deliberative process. Of course, construction projects in the energy industry tend to involve various parties, contracts, and subcontracts. Mediation can also preserve the confidentiality of sensitive disputes involving state parties. Most energy resources are, of course, owned by state parties. In the case of the dispute between the NIGC and the Turkmen supplier, the root cause of the problem was US sanctions. Situations like this, where no party is directly to blame for starting the dispute, may be especially good candidates for mediation because there can be enough goodwill between the disputants to mediate. And perhaps most importantly, as has been pointed out already, mediation empowers parties to determine the outcomes of their disputes themselves.
Yep, that sounds like there are certain disputes which are suitable for mediation. And in these cases, yeah, loss of time and loss of money might be avoided by it. Very much something that people should look into more for mediation and for solving these disputes in the oil and gas industry. Thank you very much for these insights. Now, I want to turn to a completely different topic. Again, you see I'm hopping around a little bit here. I would like to know, I'm an attorney, and as an attorney, I'm usually quite into confrontation. I want to prepare my briefs and I want to present them in court. I want to smash the other party. Now, I believe that in mediation, this might not be necessarily what I should be trying to do. Amanda, would you agree with me?
Mandy, we can't hear you.
Bad joke, that's all. Smashing is an underrated skill, but so is mediation advocacy. Parties and their lawyers seek to use their advocacy skills in mediation must remember that smashing is generally not the objective, should not be the objective. The role of a mediation advocate is very different to that of a courtroom or arbitration advocate. The mediator is not an adjudicator. Lawyers need to repeat this to themselves before they start speaking in a mediation. Mediator, not adjudicator. The role of the mediation advocate is not to persuade the mediator, but rather to try and persuade the other side that, like a piece of Swiss cheese, their case is full of holes, or at least has some weaknesses in it. This is not the moment to impersonate Atticus Finch delivering his closing argument to the jury in To Kill a Mockingbird. Opportunities for advocacy abound in mediation, from the introductory call or meeting with the mediator prior to the mediation day, which takes place in many jurisdictions, to the drafting of the mediation position statement, to the potential preparation of a confidential briefing for the mediator in appropriate circumstances, to the opening statement, and beyond. A savvy mediation advocate, as we know you are, Michael, when you're not smashing things, will treat each opportunity to make an impact with the respect it deserves and make full use of every interaction with the other mediation stakeholders. In many legal traditions, particularly when dealing with larger disputes, mediation advocacy initially focuses on the written documents. The parties should make full use of their opportunities to submit, as is usually requested either by the mediator or as agreed by the parties, a mediation position statement. A good mediation position statement will not rehash the parties' previous correspondence or statements of case. This is not an opportunity to regurgitate everything you have spent the last few months writing. It represents a confidential, without prejudice opportunity to try a fresh new approach designed to achieve maximum settlement impact. The mediation position statement should be drafted with multiple audiences in mind. The mediator, the other side's legal representatives, if they're legally represented.
No. To me, you're interrupted at the moment.
Mandy, we lost you for 10 seconds.
Yeah, so.
I'm so sorry. I'm so sorry. Please, I shall try and rejig. I apologize if I repeat a few words. The mediation position statement should be drafted with multiple audiences in mind. The mediator, the other side's legal representatives, and
You're gone again. We've lost you there. Don't know if you can hear me.
the party who is submitting.
You were gone again for another 15 seconds.
I stopped speaking. I felt that I disappeared, and so I stopped speaking. I do apologize.
Okay.
I'm not sure what's going on. Okay, take three.
Yeah, let's go for it.
All right, it's normally desirable to communicate a genuine commitment to the mediation process and the goal of achieving settlement. Setting the right tone is key. The content will depend on the parties' goals. Take the opportunity, for example, to set out the live issues in the case as your side sees it, whether there's any common ground, because it's good to have something to build on in a cooperative voluntary process, and highlight anything that you think remains outstanding. What do you need to know in order to settle this matter that you don't already know? Remember, conduct your case analysis first and development your settlement strategy, draft second. Now, if you choose to share a confidential brief with the mediator, providing information that you're not content to share with the other side, such as commercially sensitive data or perhaps the identity of a witness who's asked that their name not be shared unless litigation is necessary, but they've given their evidence, use the opportunity to put the mediator in the strongest possible position to help the parties achieve a settlement. Remember, the mediator is there to assist the parties. They can best do this if they are treated openly and taken into the parties' confidence. And that brings us to the all-important opening speech. This may be the first time that the parties have met face-to-face in quite some time. Whether the party, their lawyer, or both speak, the purpose of the opening statement is to try and influence the other side in order to further your settlement strategy.
That was longer than last time, but we lost you again. Don't know if you... I'm just going to wait.
It may be to highlight the sides.
You were gone again.
Sorry, I don't know why this is happening. I do apologize. My signal's absolutely fine, so it's a little bit strange. This is not my fault. This is not my plan to make my time.
Nobody's blaming it on you. I'm giving you more time at the moment, so do not worry.
I'm grateful.
No, again, you're gone.
I've gone again.
Yeah, you were gone the second you started speaking, so let's try one more time. Now I can see you speaking, but I cannot hear you.
Mandy, you may be on mute.
Ladies and gentlemen, an illustration of what can go wrong in an online mediation.
Very well done. Thank you for that demonstration.
Whether the party, their lawyer, or both speak,
If I may propose something, maybe we give you a short break and move on.
I think that may make
sense. That's okay for you. I'm not tired of trying. I'm very willing to keep trying.
No, I think I'm not sure if it's my end or elsewhere, but I do apologize.
Let's just give you a short break and maybe give your network connection a short break. And let's turn to Kabir. We haven't heard from you all day, and that's my fault because I'm the moderator. So I'm very grateful for the technical difficulties because I can correct my own mistakes. I would really like to hear from you a little bit more about, again, history. I'm a history guy, about history in all of the Middle East, about mediation in the Middle East. I've already myself mentioned the Holy Quran in the very beginning, but I'm very sure that you are more knowledgeable about that and that you can give us some more insights.
Thank you. Let me just begin off by acknowledging, like all my prior speakers, how delighted I am to be here in company of friends in a country that has a very special place in my heart. Farsi is, I think, one of the most beautiful languages around. So very, very delighted to be with all of you. Michael, I was going to say you kept beauty after intelligence. You've heard everybody smart, and now you had the beauty speak. You've sort of set the bar very high with that introduction. I feel a lot of pressure. But let me just offer some of my thoughts when it comes to mediation in the Middle East. And my starting premise is that mediation in the Middle East is something that has had a very rich and long tradition. In my humble submission, mediation is as Middle Eastern as it can come. So we should not be looking at mediation as a Western or a European, Anglo-American concept. It is actually, in its essence, a Middle Eastern concept. So that's my first submission. I look at the work that an organization like TRAC is doing as really going back to this genesis, going back to this rich tradition. And let me just talk a little bit about this. The notion of mediation in the Middle East has a particular term. It is called as al-wasata, where you have a trusted person who will intervene in the resolution of a dispute. Now, for people who are familiar with Islamic history, there is a very critical hadith from the life of the Prophet that really illustrates that in the 7th century, mediation existed. Now, this is one of these hadiths that has unanimous consensus, right? When you're looking at the veracity of a hadith, this has unanimous consensus. That is, the Kaaba in Mecca is being rebuilt, and the tribes in the Middle East are fighting as to who gets the right to put the black stone in the Kaaba. So the communities are fighting. And the Prophet steps forward as a mediator and proposes, let's take a big cloth, let's put the black stone on the cloth, let's have one member of each tribe stand around the cloth, let's hold it together and put it in Kaaba. Think about this. Had an episode like this not have happened, you can imagine the bloodshed, how the tribes may have gotten together to fight. But here you have a very clear instance of how, in the 7th century, a technique of mediation is used to resolve the dispute. Just a little bit more on mediation, looking at it historically through an Islamic lens, you have the notion of sulh, S-U-L-H, right? What is sulh? This is the equivalent of what you would call as a settlement, right? And again, the notion of sulh can be total, partial, or conditional. Think about it in a Western concept, right? You can have a total settlement, partial settlement, or a conditional settlement, right? In the West, you talk about mediation typically culminating in a settlement agreement. In the Middle East, the sulh will culminate in a public ceremony called as a musalaha, right? Think about these notions. You are seeing what the West has, but you're seeing an equivalent in the Middle East. And I would just encourage everybody that when we're thinking about mediation, look at the West, look at these other examples, but also look at the history and tradition to see how we may be able to combine them to come up with a model that is unique, that is very, very, I think, Middle Eastern, so to speak. Michael, I'll stop here, but happy to take any further questions.
That is a very nice closing word that you gave us here for your discourse about the history in Islam and in the Middle East of mediation. And I really like that you encourage people to look at what is the Middle East doing, what is the West doing, and how can we find a way that unites the best of both worlds, so to speak. How can we progress by cooperating together? Now, we have heard, against this huge tradition, which I see and which I very much estimate very highly, we have seen that there are certain obstacles to mediation today in Iran, possibly in other countries in the Middle East as well. Now, how do you see these obstacles? How would you tackle them? You've answered it with one thing, that is cooperation, looking at how things are done in other countries. But are there any other pieces of advice that you would like to give, that you would like to share?
Sure. I mean, look, I think the Middle East, in my submission, is no different than any other regime anywhere around the world. Mediation has had certain difficulties, the lack of a regime, the lack of a framework. We must commend what TRAC is doing in this regard, right? Because you often need a robust framework to help the resolution of a dispute. TRAC is on the forefront trying to do that. You are seeing in the comments, right, the need for greater collaboration in the Middle East, and more generally, collaboration of arbitral institutions. We have already seen our own doctor here share the view that, yes, that is something they are thinking about. Obviously, you want to collaborate. I think these things have to be staggered, step by step. But it definitely seems to me that is something, we can all work together. We can work with other regional bodies to try and make a difference. End of the day, right, we're all trying to support the same cause, right? Amicable dispute resolution. So, I mean, I do to echo what Doctor said, I do look at this more optimistically. I do think that the future is bright. And while there are obstacles, I don't see any obstacle here that is so difficult or so unsurmountable that we have no solutions. I can go on, but I will stop here in the interest of time.
I do have another question for you, so I'm thankful very much for you stopping here. I know that you could go on for hours about this topic. Yeah. Now, you have mentioned sulh as one of the things that feature in the Holy Quran, that feature in the Hadith. There is another word in Arabic, and I do not know much Arabic, but the word is tahkim, which means in our terms arbitration. And turning back to some of the other insights that we have heard today, it seems like there are certain disputes which would be more suitable for sulh and other disputes which would be more suitable for tahkim. Now, what would be your view on which disputes should go to arbitration directly and which disputes should go to mediation, or to mediation first if you want to go to arbitration afterwards?
I'm going to take a controversial position, but my controversial position is any dispute that can be arbitrated can be mediated. That's my fundamental starting premise. If you can arbitrate it, you can mediate it. Now, putting that argument aside, there's certain areas we cannot arbitrate, and therefore you cannot also mediate. Criminal law becomes one of those matters. Sometimes matters of fundamental rights you cannot arbitrate. Let's put those aside. The conventional wisdom will tell you that if there is a complete breakdown in relationships, parties may prefer arbitration over mediation. You have nothing to salvage, right? Breakdown of relationships, in my humble submission, is again one of those things. It may have broken down today, but if you believe in the Hollywood saying, no permanent friends, no permanent enemies, your enemy today may be your friend tomorrow. So I would still say give mediation a shot. But that aside, I still stand by the general view. If you can arbitrate, you can mediate. And you are probably better off trying to mediate, because you may be able to reach a compromise that in an arbitration becomes much more difficult. The adversarial nature, right, will lead to just greater confrontations. But this is the optimist in me. You have heard optimism from each of our speakers. This is the optimist in me. Humanity should try to solve disputes amicably.
I really like that optimism, and I really love the energy with which you are showing us that optimism. And I think that we all should, take a little bit of your optimism next time that we look at a dispute and have to decide whether we are going to give mediation a shot or not. And I would opt for giving it a shot, because to echo you, if you can arbitrate it, you can mediate it. I like that saying. I very much like it. Now, I've seen a raised hand, or was that in support? Ovais.
Yeah, I just want to add a few words to what Kabir just said and put one step more forward and say that even some disputes that are not arbitrable, they can be mediated. So, like in Iran, we are not allowed to refer the disputes arising out of the bankruptcy to arbitration, or family disputes are not allowed to be arbitrated. But still, nothing should prevent the parties to mediate the disputes like bankruptcy or disputes arising out of bankruptcy, or even the family disputes. Therefore, not only what Kabir said is true, but also we can take one more step forward.
Fully agree.
Yep. There is nothing else I could add to that either. It's something I completely agree with as well. So should we try again, Amanda? Would you like to finish? Would you like to try your network connection?
Are we feeling lucky? I've switched. As you can see, there's a different part of my room now. You can see it's very exciting. More rubbish behind me. So let me try and finish my my couple of insights for those wishing to conduct successful mediation advocacy, aside from checking the accuracy of your internet connection. So I was talking a little bit about the opening speech. This may be the first time the parties have met face-to-face in some time. Whether the party, their lawyer, or both speak, the purpose of the opening statement at the mediation is to try and influence the other side in order to further your settlement strategy. It may be appropriate to communicate the strength of your position or strengths of the other side's position. You may want to highlight that their proposals are sensible or that they're not sensible. And you may want to highlight any further information that's required to make progress, or suggest some sensible concessions that are made in order to move forward. Now, if you do choose to make concessions, make sure that you're clear about whether they're made solely for the purposes of mediation, or whether those concessions will continue to stand even if you proceed to an adjudicative process in due course. Now, parties with lawyers often find that they like their lawyers to speak on their behalf, but it can be cathartic for the party to have the opportunity to speak. Because if the mediation is successful, there will be no day in court. There will be no day in arbitration. That will be it. So if you've got something you want to get off your chest, sometimes it's better coming from you as the party. There are no rules about who may speak at mediation. So think very carefully about who should deliver the message and who will be able to deliver that message most effectively, who will have the greatest impact. Now, remember, online mediation presents its own practical difficulties. If you read from poorly positioned notes when delivering your opening statement, you may find that this is what people will see, which is not a very effective way to deliver advocacy. So make sure that you position your notes effectively. Try to retain some semblance of eye contact with the people to whom you are supposed to be speaking. So if, for example, you use gallery view in video conferencing, be careful not to allow your eyes to be drawn to the edges of the screen. Does this happen? This is not effective advocacy. If you're able to focus on your camera, you'll appear to be looking at every participant directly. Don't stare at them. I'm not having a staring match. And sometimes it helps if you position your notes immediately below your camera. Now, on a positive note, in many ways, remote mediation advocacy in particular can be a great equalizer. All the speakers will be sitting down when they speak. So a more polished speaker with greater presence is not going to have the same level of advantage as they would have in a live room. The size of a speaker of smaller stature, such as myself, will be less obvious. I look bigger in this little square than I look in real life, I can assure you, for those who've met me in person. So advocacy, although it's always challenging, may be somewhat less intimidating as a result. So I'm hoping that everybody managed to hear all of that this time.
Yes, we did. We heard it very well.
Thank you for your patience.
You had your day in court, your day in mediation, so to speak. You were here to deliver it. I have one follow-up question for you. I would like to know, we have heard many very good tips for mediation in general. Do you have any tips for specifically companies or people based in the Middle East or in certain Middle Eastern jurisdictions, how to conduct an effective mediation?
Well, I have some tips that are a little bit more Middle East specific, but most of my tips are fairly general in nature. Now, as Scar sang in The Lion King, if you've all seen The Lion King, the trick to a successful mediation, particularly of the remote variety, is to be prepared. And this is the song from The Lion King for those who know their Disney films. Preparation must start from the earliest possible stage, and this applies for parties whether in the Middle East or beyond. Make sure that your mediation agreement adequately addresses key issues that may arise, particularly in a remote mediation. Companies in the Middle East may be dealing across borders. The underlying documents may be in different languages. It may be necessary to transfer documents securely, so we may have issues arising relating to confidentiality and cybersecurity. Remote mediation should not give parties a license to invite strangers into the confidential discussion space either, or to take screenshots of documents that have been disclosed on a site-only basis. Now, James has mentioned that his survey has highlighted that remote mediation presents an increased number of distractions, and that's seen as a disadvantage. And so parties relying on remote mediation to address their cross-border dispute need to be particularly cognizant of things that they can do to address and minimize those distractions. Parties should select a mediator who ideally has experience using the technology to be used during the mediation, or at the very least a mediator who's completed the requisite training. And this is a place where institutions can assist. They will have a better idea of the background of mediators than individual companies operating in the Middle East. Technical competence should be considered alongside status and reputation. After all, parties are much more likely to respect a mediator who is in control of all aspects of the process, including the online space, if you're using an online space. Now, my research has indicated that respect is often of particular importance when it comes to selecting a mediator in a mediation involving parties from the Middle East. It's really important that the parties have confidence in the mediator and they are able to respect them. And one way of losing people's respect is not being able to appear on the screen or speaking for 15 seconds when nobody can hear you, as I've managed to demonstrate today. So having the requisite training, the requisite experience is really important when it comes to developing and maintaining that respect. If parties speak different languages, which they may do in different parts of the Middle East, Arabic, Farsi, Persian, English, and many other languages beside, it might be necessary to consider whether simultaneous translation may be required when it comes to making practical arrangements for your mediation. Whether you're online or offline, translation raises complications. Online in particular, you may need to choose a platform that can accommodate simultaneous translation so as to ensure that the proceedings can move swiftly ahead. Zoom, for example, does accommodate simultaneous translation. Translators may need to be booked, and of course, they'll need to be asked to sign suitable confidentiality undertakings, particularly if you're talking about personal issues or commercially sensitive issues. To maximize the efficacy of joint and individual sessions, whether online or offline, it's a good idea to try and establish some ground rules, and ideally some sort of protocol, particularly in the online environment, to address any issues that may arise, particularly technical issues. Now, those ground rules may include things as simple as not using the chat function for internal communications. It's very easy to accidentally send the other side something that was meant for the eyes of your side only. Parties need to make sure they have access to the right equipment as well. Good lighting, a decent internet connection, and a backup connection. This is the backup connection, ladies and gentlemen. A good quality camera, a decent microphone. Contingencies need to be put in place in order to address equipment malfunctions, making sure that the parties have the video conferencing dial-in numbers, and they can join with audio only if necessary. If you're turning up in person, there are obviously all sorts of practical considerations. Make sure you know where the mediation venue is. Make sure you've got a little bit of time built in to ensure that the person who inevitably will be late is not going to cause offense to the other side when they rush in. Hair sort of in a mess, luggage deposited on the table and so on. You need to create the right environment at a mediation. Dumping your possessions on the table and collapsing with a heart attack is not the right impression. So time management is really important in mediation. If you're using online facilities, consider the availability of software such as Adobe Sign or DocuSign if a settlement agreement or heads of terms may need to be signed in due course. If you have a pre-mediation introductory discussion with the mediator, use that opportunity to gain an insight into the mediator's preparation style. The introductory, and if the mediator hasn't suggested an introductory meeting, then parties, whether in the Middle East or beyond, may want to suggest that they have a brief call with the mediator, just to have that opportunity to introduce themselves. This isn't arbitration. There's no bar on the mediator communicating with only one party at once. The nature of mediation is that at some point during the day, the mediator will be communicating with the parties individually. So there's nothing wrong with having a discussion. The mediator will be expected to
be conscious of their own ethical obligations. That sort of meeting is also a good opportunity to test the technology if you're operating online. Some platforms do not work in every jurisdiction. There are a number of platforms, for example, that may not work in Dubai. That's been an issue I've had on a number of occasions, particularly during lockdown. Certain platforms are not suitable for certain jurisdictions. So it's really important that those sorts of issues are considered in advance and addressed. The mediator, in conjunction with the parties, might want to think, for example, particularly if you're working across different time zones, whether the mediation may be more effectively conducted over, for example, 2 half days to avoid screen fatigue or to avoid general fatigue by the parties. If you're dealing with an institution and you're dealing with remote mediation, you may want to explore solutions for those who don't have good quality internet connections. Is it possible for the institution to lend the parties a dongle with high-speed internet access, for example? These sorts of practical considerations can be taken into account. I said most of these tips were general, and I'm going to conclude again on a general basis. On the day, make sure that somebody with the authority to settle is available throughout the proceedings. We've talked a little bit about respect. It's very disrespectful to turn up to a mediation and admit that you're not actually in a position to settle. And this is disrespectful regardless of where the parties are from. So it's really important that the right people are there. It's a mark of good faith, and good faith is really important in mediation. And one of the big losses of remote mediation is the fact that you lose the ability to pick up on subtle body language cues. So do try and use cameras where you possibly can, however frightening it might be for the participants early in the morning to be mediating. So just a few tips. I'm conscious that they're not Middle East specific, but the reality is that so many tips relating to mediation are universal.
Those were really, really good tips for everybody facing a mediation, and they were very picturesque. And may I just say, you already had me at Lion King. It's one of my favorite movies. Thank you for that. So I believe that this already would conclude our general session, and we have a few minutes left for questions from the audience. Now, technology, manage your technology is one of the tips, if I remember, that we heard. I'm trying to access the chat window at the moment. I cannot see the questions yet. Do we see questions here? I'm trying. They disappeared when I enlarged it. That's great. Now here they are in small. I'm going through them. I can see Philip Ray. Nice to see you. I can see Sima Rafari here as well. Nice to see you as well, but there's a lot going on in the questions. Could somebody type a very short question for us that we can address? Or did any of you read in the chat window? Because I was listening, I cannot read while I'm listening. Did any of you read the questions? And is there one of the, things that you would like to address that you would like to go through? Here we have a question. So when parties are ready to go to court, it means they do not trust each other anymore and their relation is now broken. So how a lawyer can push them to mediation process? A question from Hamid Zatayan, and I hope I say your name correctly. Zatajan, maybe.
Sure, let me take a stab at it, but this can be an open invitation for everybody to join in. I mean, Hamid, I think you're totally correct. If parties are going to the court, clearly there is a problem. As you have said, there is a lack of trust. The breakdown may not be absolute though, right? And therefore, mediation offers a very viable solution. That is, let's try to salvage and create the proverbial win-win situation. Very often, if you go to a court, if you go to an adversarial or a stricter adversarial process, your positions get more entrenched, lawyers get involved in a very firm manner, it becomes legal war, for the want of a better description. Mediation can avoid some of that. If you have a buyer-seller relationship, if there's an ongoing relationship, it's better not to take the nuclear court option and try mediation. You may come out better and you may save some bucks, both of which are good goals in my submission. I stop here, but welcome any other reaction.
That sounds like a very good answer to that question already. Would anyone else like to add something to it?
In a number of jurisdictions, if parties choose not to take advantage of their opportunity to use ADR, they will potentially face cost sanctions, which tends to be a reason that appeals to parties when it comes to deciding whether or not to mediate. If it's going to cost you money not to try and sort out your differences privately without bothering the courts, parties seem to be more interested in making an attempt. So I will just add that. That's a less positive note. Kabir has gone for the positive, I go for the negative.
Which can have a very positive incentive in the end as well. I would hope so, at least.
I have very little to add. I'll just add one detail. I think possibly sometimes there's resistance from parties because they don't really understand the mediation process. So I think it can be useful for counsel simply to explain the comparative advantages and go through a robust risk assessment with the party about what might happen if the case doesn't settle.
Indeed, yes. That goes back to advocacy in mediation. That is a very good advice as well. I see we have another question here from Phil Ray, actually, and I'm saying his name because he's based in my hometown, and I'm giving shout outs to people from my hometown. So his question is, in small business contracts to rebuild Gaza, how can a mediation clause incorporating TRAC, TRAC, or Middle Eastern entity rules, for instance, SCCA, compete against a clause incorporating internationally recognized mediation rules, such as the DIS, the ICC, ICDR, SCC, and all the names?
I'm happy to begin, but James, please. I was going to wait for somebody smarter to start. Please.
No, go ahead, Kabir, please. By all means. No, I think I was simply going to say I think the question's really about how can a regional institution compete with institutions that are already more well established, and I think in the space of mediation, it's everyone is sort of starting at the beginning. As I mentioned previously, I think the international framework is just now being put in place. Add to that the possibility of online mediation, and I think regional institutions are in an especially competitive position. Moreover, as I mentioned previously as well, I think that regional institutions, the services that they provide, they might resonate more with businesses in the region for reasons of language or reasons that they know the culture. And so there may actually be the possibility for regional institutions to gain traction in a region, whereas it might be more difficult for a more established institution from the outside to penetrate.
I could not say this better. To be quite honest, I don't have much more to add. But I would just say cost can be a significant factor. A lot of these international organizations that are great, but they charge in euros or in dollars. Now, when you start doing the math of conversion, a small dispute can suddenly appear a lot more expensive. And just, matters like Sharia law, having local specialization, having people who can speak Farsi, who can speak Arabic, you may find better solutions with local and regional bodies than you may. This is not to say that international organizations can't, but it's going to be a body on the ground, knows the realities on the ground better. And, it benefits dispute resolution globally when we have organizations that are local, regional, continental, international. We need all of them. So.
Yeah, indeed. I believe that's the best answer. The two of you gave the best answer together to that question. I have another question here from Sima Rafari, who says, considering the potential obstacles, is it the time now for the countries like Iran to ratify the convention? I believe she means the Singapore Convention. In your idea, since at the domestic level, there are some questions with regard to enforcement of, I believe, settlements reached in mediation.
May I?
Please.
Thank you. Yes, I believe it is the time. I mean, in 2001, when Iran joined the New York Convention on Enforcement of Foreign Arbitral Awards, not all the infrastructure for arbitration was provided in Iran. Those arbitration centers in Iran were established after the ratification of the New York Convention. It meant that the ratification of joining the convention helped to accelerate the road of promotion of arbitration in Iran. So I believe that this is a good step that the Iran government took to join this convention. And well, we will soon have the parliament to ratify, particularly because the Guardian Council in Iran declared in advance that if the parliament ratified it would not have any objection to such ratification, which is a very good sign in Iran legal regime, which means that the convention will be accepted by all judicial and all state bodies very easily. So I believe a very short answer to Sima is that yes, I believe it is helpful, and this is a great step.
Thank you very much. We have two more questions. I'm mindful of the time, so I'm going to admit these two questions and then we'll wrap it up. The first question comes from Chloe Dykmans. The topic of the transition of mediation onto an online platform was addressed. Do you think that in-person mediation will become completely redundant in the future in the Middle East? Provocative, I must say.
Not anytime soon. I think not anytime soon. I think my impression is that there still is real difficulty communicating in the same way online as in person. There's a lot of really interesting research being done now in how to address that particular point. For example, there's research about how having our camera on so that we can see ourselves is quite stressful and it's quite distracting. So I think there are small things that we can do to improve the quality of conversations, and I believe that will continue. Maybe at some point we'll get to the point where everything is online, but I don't anticipate it will be soon.
Just to follow up from my own view, what about hybrid mediations where some people join by means of an online platform and others are in the room in person? Is that something that you would see increasing in the future?
Happening. I'm aware of hybrid mediations.
Can't hear you. Sorry.
Can you hear me now?
Yes.
Yes. No, I was just saying yes. This is already happening. I'm aware of hybrid mediations that have been successful and that have led to settlement. So I think you're absolutely.
We lost the last word there and you're frozen. But let me just turn to the last question and we get back to your last word when you are back. So now people are writing. Let me just switch there. It says it's from Zahra Moshref, and I'm again hoping that I'm not butchering your name. How can we elaborate the role of mediator in dispute settlement? As in Iran, people, including experts, consider mediation the same as arbitration. So that probably goes a bit in your direction, Luis, I would say.
Well, I would be very happy if I learned that Iranian people are considering mediation like arbitration, because, I mean, arbitration has now found its place in the Iran legal regime. But I doubt that would be the case, because people, except experts, as you just mentioned, Zahra, people are not considering the mediation as strong as on arbitration. But the matter is here that what people are looking in arbitration should be different from what they are looking in arbitration. When they go to arbitration, they are looking for an enforceable, binding, final judgment. But when they come to mediation, they are looking for a sort of solution to resolve their dispute in any way. So I believe that the proposed and the goal of the people who refer the dispute to arbitration and mediation should be different. And what we are going to do in promotion of mediation is to highlight this difference.
Right. Yes, that goes back to your initial remarks that education about mediation is key for its success. Now, James, I can see you're back. Do you want to say your last word? That was cut off, or?
No, I'm sure that
All right.
the conversation has moved on, but thank you for asking.
We have one follow-up question, and that is definitely going to be the last one now, from Mehrdad Nazemi, which says, how do you reconsider now, and that's with respect to the Singapore Convention, when most industrial and economic world powers have not ratified it yet? So does that give you any things to reconsider?
I don't think so. I think that the decision should be made about whether it's good for Iran, and that it shouldn't be made through the prism of what other countries are doing. It may well be that because of the COVID pandemic, countries haven't moved as quickly as they might have otherwise.
That is just a very short and wonderful answer to that question. Thank you very much. And, yeah, to wrap up our session today, we've heard many different insights from experts from many different countries here. We have had very interesting questions, and I'm not speaking about mine, I'm speaking about the ones from the audience. I personally have learned a lot today. I very much enjoy any session about mediation because we have this cooperative spirit that is just present in every one of us somehow. Everybody that's dealing with mediation is there to solve disputes efficiently, quickly, and cost efficiently as well. So let me close by saying two of the only Farsi words I know, Tashakur Mikonam, for having us here today. It was my pleasure to be your moderator. I hope I did an okay job at doing that, and I wish the very best for the future of mediation, in Iran, and I hope to see you all very soon, and very soon again in person. Thank you.
Thank you very much.
Thank you.
Thank you very much for joining us.
Right.
Goodbye.